ethics meeting to order and to give an introduction about our work on the Ethics Committee. I just want to say three things. We exist to promote public confidence by ensuring both the reality and appearance of integrity in village government. We guide and protect village employees and elected and appointed officials to help them discharge their duties without fear of unwarranted accusations of unethical conduct. And we help in a benevolent fashion everyone avoid unintended ethics violations before they occur. Those are our goals and things that we are concerned with. Our next thing is to say the Pledge of Allegiance. I'm just following the agenda, so we can join in on that. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And now we have a roll call. I call our members to order. Craig Goldberg, are you here?
Here.
Thomas Kempner.
Here.
Teresa Melhado.
Present.
Susan Steinhardt.
Here.
And Attorney Gray.
Present.
And my name is Stephen Pfeiffer, and I'm also at least partially present. We are considering 5 documents today, if we can get through them. The first 2 are procedural documents that we need to have on file in case we need them. And the last 3 documents are pertaining to an ongoing case that we're trying to wrap up that has been on our docket for a while. So without further ado, I'd like to go to our first procedural document, which is called Procedures for Conducting Fact-Finding Hearings. This is a draft of a document that we need to provide people when we have to have a hearing and invite people to testify before us. Does everyone have a copy of that before them?
Yes.
I apologize. I did not number these pages. I numbered them just a few minutes ago. In my format, there are 7 pages, starting with purpose and then complaints and so forth. I'll open it up to our members to have any comments or changes or anything that they want to consider at this time.
Stephen, it's Craig, and since I'm new here, when I just had a 30,000 foot level, when I looked at procedures for conducting fact-finding hearings, and then procedures for due diligence for due process hearings, it seems that they overlap quite a bit. And does it make sense to really merge them into one document, since a lot of the sections are repetitive?
Makes sense to me.
You want to combine the 2 into one document?
Well, the question is, when you look at procedures for the title for conducting fact-finding hearings and then due process hearings, again, I'm new and I'm not a lawyer, but it seems that a lot of what's covered is duplicative. So, and then when you look at, for instance, I have page 5 on mine, but if you go to the last sort of section of the document, it says fact-finding hearings, bullet 5, when you get to little I in the whole, when you look at rules of evidence and record of hearing, on the last page, those 1, 2, 3, 4, 5, 6 items really don't pertain to evidence. They really repeat what was in the due process hearing document. So I think it's a matter of just perhaps formatting. Those are that's sort of just a high level comment.
Okay, so you're talking about page 5 of the document at the bottom, starting with the little I, little number, and those 6 you want those to be reformatted or taken
Well,
out?
though, no, but those are not rules of evidence. So if you look at
Oh, I see.
number
The
5
heading.
rule, yeah,
Yeah,
the rule,
okay.
yeah, so that should maybe be number 6, because they're not rules of evidence.
Okay, all right, all right.
See what I'm saying?
Yes, I do. So, do you want to start that new heading before the word "except" at the bottom of the page?
If I might make a suggestion, I think Craig's idea of combining is probably a good one for efficiency's sake. And in fact, as we can recall, I think it was Steve Leventhal who said that we should look to his fact-finding hearings protocol to glean from that the due process. Isn't that correct, Stephen?
That is correct.
Okay, but if I might suggest, I think that if we could for now go through each one separately with comments, and then we could, if it works, we could combine the two.
Makes sense.
Okay, but I just want to follow up. Craig, do you want us to change anything in the first document now?
Procedure, the document says conducting fact-finding hearings. That's the document. I just want to make sure I'm on the right document. I have.
Yeah.
Yeah.
Do you want any changes in that
Oh,
document?
sure. I think to be consistent, if you're under one purpose, it says the Village of Southampton authorizes the Board of Ethics. I think what we should do is elsewhere in the document, define that as parentheses, quotation, BOE, all caps, parentheses, close, paren. And then throughout the document, do a global replace. Because in some places, we refer to Board of Ethics, other it's BOE, others it's the board. So
Okay.
I just, that's pretty simple.
Yep.
I think going to section 2 complaints. It says an investigation by the BOE may be initiated. I think it should say will be initiative, at least a preliminary investigation, right? Because that might be somewhere
Okay,
else.
changing may to will.
Right. Upon receipt of it should say written complaint. Because then down below at the end, you could probably strike out all complaints shall be in writing.
Okay.
I just think it makes it.
Yeah.
And then
instead of the word will, you might want to use shall.
Shall. Okay. Yeah.
Okay.
The next page, well, actually, piggybacking on Craig's comment, in many instances, I have question marks when the board is empowered to act. And the question mark really had to do with, is it one person who can have the board act? And this is really comes to mind when on this second page, in the paragraph that was added, a couple of sentences down, it says, if the initial request is judged to fall within the purview of the ethics code, as many of the board as possible will consult together. That needs to be tightened up.
So we want to leave out as many, just say the board.
No, it should always be majority, I think.
You're on
Well,
you're on the fact finding hearings page. It says, let me just see.
Page 2, middle of the page.
Yeah.
Oh, yeah. I would say subject to majority vote of the BOE, right?
Well, you need a quorum to act as a board anyway. At least 3 of you have to be present anyway. So you're going to need at least a quorum of the board.
But that's not what this says.
I agree with you.
So we, yes, so we should, I hear what you're saying, and that makes, that is the right thing. This needs to be crossed out then. So we
Because
don't get into problems of what supersedes what, you know?
Okay, do you want to read me what you want the sentence to read?
Can I just,
So the
What-
whole paragraph, in the set, you start with the second sentence. If the subject matter is not found within the purview of the board, well, how does that process work?
Well, again, should we have it be a quorum decides this?
Quorum must always, a majority must always decide, in my view.
Okay, how does that sound?
Well, I
Well,
don't, yeah,
it should read, if the initial request is judged to fall under the purview of the ethics code, comma, a quorum of the BOE shall meet to issue a ruling as soon as possible. But here's my question. What's the intent of that sentence? Is it to issue a ruling just to say, yes, it falls under our purview. Now we're going to start an investigation?
well, can I just make a suggestion? Because Susan, we jumped to page 2 and I was still under
oh, I'm so sorry.
under complaints, because it ties into that. All right, so like on the second bullet point under that, you could say the BOE will promptly acknowledge the receipt of a complaint as opposed to all complaints. On the third bullet point, upon receipt of a complaint, the BOE will, should we say, conduct a preliminary investigation versus determination? Because don't you have to do a preliminary investigation before you can do a determination? And then whether the facts alleged, facts are facts, so would it be with the alleged actions, or I mean, maybe this is semantical and some of the lawyers are out there. You could say upon receipt of a complaint, the BOE will conduct a preliminary investigation as to whether the alleged complaint, if proved, would constitute an ethics violation, or whether the alleged actions would constitute. Because facts are facts, right? You know,
Okay, so-
you can't allege a fact, right? If you say, well, I'm in Utah, but right now I could say unequivocally, the fact is it's the sun is shining. So that's not an alleged fact versus an alleged action or something that would rise to a potential ethics violation. So it's just upon receipt of a complaint, the BOE will conduct a preliminary investigation as to whether the alleged action, if proved, would constitute an ethics violation.
That's good.
All right, so you're on mute.
Who's on mute?
What?
I said that
Teresa was
sounds
on
good.
mute.
Thank you. That sounds good, Craig.
Okay. And then if you go to the next point, and that gets to the notice, it says if the BOE determines that the actions alleged in the complaint would not constitute an ethics violation, the complaint shall be dismissed and notice of the dismissal shall be provided, blah, blah, blah.
That sounds good. Okay, now we're back to Susan.
Now we're at number 3, which would be notice of hearing, right, Susan?
Well,
No,
we're-
it's the
we-
paragraph that was added before notice of hearing.
Okay, let me get a different draft then. I have
Where
a
it says
different,
as
yeah,
many as possible can act.
okay.
Okay, so
Let me
that
get,
You see that, Craig?
maybe it was, I don't have that in mind. Could be, let's see if there's a different draft. Hold on a second.
okay, Susan, while
Okay, now I-
you want to have a sentence? You're going to substitute a sentence for if the initial request?
So, well, above that, in the second sentence, in my view, in each case where there's an action, there must be a majority vote to act.
Okay, so
So
if the
the
second sentence, yeah,
Sentence says, if the subject matter is not found to be within the purview of the board, well, who makes that determination? For me, it's necessarily the majority of the board who make
okay,
that.
so let's change it to if the subject matter is not found to be within the purview of a majority of the board? No,
If a majority of the board
yeah,
determines that the subject matter is not within its purview,
mhm.
then go on from there. We're gonna have to see this again, Stephen, I think.
Of course,
We're
of course.
workshopping now, and who knows how it's gonna end up coming together.
If the subject matter is not found to be within the purview of the board, if a majority of the board does not find a subject matter to be in its purview, to the appropriate municipal authority.
Ken, you'll write this up? Is that how this happens? I don't know.
I think Stephen's taking lead on the redrafting of the document, correct, Stephen?
I'm trying to. Will I be able to review this this recording?
Yes.
Well, then, that's good. Okay. What's next, Susan?
It goes down, it said, if the initial request is judged to fall under the purview of the ethics code. So one point it says purview of the board, and then this is the purview of the ethics code. So as many of the board as possible will consult together and issue a ruling as soon as possible.
And what you should say there is, after the comma, you can just say, the BOE shall meet to issue a ruling as soon as possible.
one question, and this goes through the document where we say, within a reasonable time frame or as soon as possible. Does it make sense to put in a time period within X days, weeks, months? Because.
Or in our case, years.
Right, whatever. But, the question is what's reasonable, what's fair? I don't know if people will get, picky on that, but if you say we will issue, we will make a decision within X weeks, or notice has to be given in within Y time period. I comment that throughout the document. And the reason I didn't see that before, Susan, is that I was working off the prior draft of the document.
What about within a reasonable time period, not to exceed a month? Because at certain times of the year, it might be hard to address
That's
it.
good. That's
within-
good.
But a month is reasonable.
That's why you went to law school.
Are we happy with that?
Yes.
Okay, what's next?
So going under notice of hearing, and again, it might be a difference in draft. Says if the BOE determines that the facts alleged, should we say the actions alleged in the complaint?
Yes.
Yes,
And such inference, and we could just say, and such actions, if proved, would constitute an ethics violation. Or if you could say the majority of the BOE determines that an investigation is warranted, the chairperson, subject to the majority of the BOE, shall provide the respondent with written notice that a fact-finding hearing will be conducted.
thank you, because I questioned what it meant on its own motion, and that resolved.
Sounds great.
Very good. Okay, moving on.
Under F, any other information that the chairperson or BOE member considers necessary for the proper conduct of the hearing.
Mhm.
Very good.
Okay. I think my next comment would be under 4 hearing procedures. With reasonable promptness, or as I think, as Teresa said, what was your wording? As soon as practical, but not more than 1 month.
Mhm.
We could use okay. Next comment would be
Should we put except within exceptional circumstances, so to give ourselves some reasonable explanation as to why we're not adhering to this time, which should be the right amount of time, but.
You can put, you might want to put at the end of the document, you might want to be a catch-all sentence that just says, any and all time constraints, contained herein may be waived or extended at the discretion of the board due to extenuating circumstances.
Good,
Something to that effect.
great.
A majority of the board.
Well, whenever you say the board, you're talking about a majority of the board. And in that last comment, when somebody mentioned something about F, where it says any other information the chairperson considers, and I think it was suggested, or any member of the BOE, it should be the board. Anything the board determines, because by inference, 1, you can only take action if you have a quorum present, and 2, you can only take action if you have 3 people voting for that. So if 3 people meet to act as the board, you need all 3 people to agree.
Got it.
So if 2 people want to do one thing and the 3rd person who's at that meeting doesn't want to do it, it doesn't pass. It's not a majority of those present, it's a majority of the board.
Got it.
We need to define that then specifically board as opposed to Board of Ethics as BOE.
Well,
To
in your
avoid confusion.
global comment up front in the introduction, I think.
Yeah, somebody suggested taking Board of Ethics and then putting in parentheses, quote, BOE, quote,
Right.
and parentheses. So
Right.
when we talk about BOE, you're talking about the Board of Ethics.
Okay, all right. Then going to number 4, it says the BOE may issue subpoenas to compel the attendance of witnesses or the production of books or records. Shouldn't we also include other information or other information, email, text, etc., phone records?
Pertinent information. Yeah.
Pertinent information, yes.
Very good.
So Ken, I have a question on the word subpoena. And that under our powers is that we can compel appearance and we can subpoena. We had, what does that exactly mean in a practical sense?
You literally produce a piece of paper, which is a subpoena, and you put in there exactly what you're asking for. So it's either a subpoena for testimony or it's a subpoena for the production of documents. So it's literally a piece of paper that you, and you tell the person what you're looking for.
We were advised by another lawyer early on our meetings that those were empty words, and we actually did not have real power to compel appearances or to issue subpoenas.
Well,
No, that's not true.
Okay.
That's not true, Susan, I don't think. We
Okay,
were told what the responses could be if we submitted a subpoena, which were lengthy. But we were not told that our subpoena power was non-existent. That's part of our code.
but the only way your subpoena powers have any teeth is
Right.
if you take the subpoena and you bring it to Supreme Court, you get it so ordered by a Supreme Court judge, and then you serve it. And if the person doesn't comply, they're in contempt of court, and then you can bring a contempt proceeding in court against them.
Teresa, you were there for that conversation. You and I had discussed that. It was a surprise.
Yeah,
It
I'm with Ken. I think that makes sense.
does make sense. So we will then put the other advice
Aside.
by the wayside. Yes. Good. Thank you.
That other attorney, obviously I wasn't there. I don't know who it was,
Sure.
but
This makes good sense.
but he wasn't wrong in that if you issue a subpoena and that is not court ordered, if the person ignores it, there's nothing. What are you going to do? Send it to him again? Send it to him a third time? If they
Right.
ignore you, they ignore you. So the only way to get compliance is to have it court ordered, and now you have a contempt proceeding.
Maybe
Are we-
that's what he was talking about.
Are we changing the wording of this at all?
I don't think you need to.
Okay, shall we go on then?
Sure. 2 points down, the respondents may be represented by counsel. Do we need to have notice? I mean, again, since I'm new here, when we meet as a board, do we have, is our counsel always present?
Not necessarily, no.
So if they're bringing a lawyer, shouldn't we have a lawyer?
Or I agree with you. We should have notice so we could decide whether would be a good idea.
Are we changing that wording then?
I was asking
Okay.
Ken that what Teresa's saying is we should have notice that they're bringing legal counsel. And then the question is, if they bring
Oh, I see.
legal counsel, do we need legal counsel?
We can decide that at the time.
Right.
Okay,
On a case,
all right.
on a
Yeah.
case-by-case basis, you can determine whether or not you want counsel present or not. And if a respondent shows up with counsel unexpectedly, you always have the ability to adjourn the matter and reschedule it so that you can bring counsel in.
Well,
Fair.
notice would be a reasonable idea, though, so that we could prepare and we don't have to adjourn and all that.
I have actually, are we finished with that point?
No, wait, just 1 second. Are we putting in the wording about notice here? That we deserve notice? We
Yes.
want notice.
Yes.
Okay. So the respondent may be represented by counsel or another representative if the respondent chooses, and the respondent must give notice. Is that what we're saying?
There needs
Josh?
to be time, there needs to be a time minimum, like 48 hours or 24 hours,
At least 48 in case we think it's necessary.
whatever it is, it needs to be a time. Not just, I'm on my way up with my lawyer.
Respondent shall provide BOE with notice of representation at least 48 hours in advance of any scheduled proceeding.
Sounds good.
Yep.
On the next bullet point says
I'm sorry,
witnesses.
Craig.
Okay,
The one,
yeah,
sorry,
Go ahead.
the sentence before, the respondent will have an opportunity to be present at all of our, while we're determining whether there's a complaint within our purview. What does that mean? Opportunity to be present when?
at the hearing.
But so I'm just playing in my head different complaints we've had in front of us. So what that means, if something is alleged, then the respondent sits in the room when we interview anybody that might be connected with this complaint or the actions that are questioned.
In other words, if we call a hearing, it's not involving the original complainant. Does the original complainant have a right to be in the hearing? Is that what you're saying?
No, it says here the respondent will have an opportunity to be present, I assume, at all of our hearing procedures. So if we are interviewing Ken for something he may have worked on with a person, that the respondent is in the room while we're interviewing Ken. Is that what this is saying?
No, I don't see the language that he has, that the respondent has the opportunity to be present. I don't see that. I see,
It's on page 4. It's under hearing procedures.
Right.
1, 2, 3, the 4th dot down.
oh, I'm sorry. Thank you. All right, got it. Yeah, was that intended for him to be the respondent to be present for the entire?
I don't know. I don't know. I'm questioning that.
I have no idea.
Well, it doesn't seem like a great idea.
The subject of the hearing should be there, obviously, but who else needs to be there?
I think that correct. And then when one plays it out, my understanding of the process is we reach a determination based upon our investigation. And then if we find a violation, then we call in the respondent and present everything at that point and give the respondent the opportunity to submit evidence, to explain whatever, and then we make our final determination. At least
That sounds like a good idea.
Well, that's the procedure. That's the procedure, and that's why we have the 2 documents, one for the hearing and one for the due process, in case we find somebody allegedly guilty or violating an ethics law.
So this entire sentence should be deleted.
Okay. Okay, everybody okay with that?
Yes.
Yes. And then,
Okay,
Stephen,
moving on.
Stephen, what do you mean the statement says may be permitted to give narrative testimony? What does that mean?
Well, that means a story. In other words, usually when I watch TV, testimony is usually answering questions or providing facts or whatever. But in this case, we're giving the person a chance to tell his story. A narrative.
This says witnesses.
Yeah, whatever, whoever. Yeah, tell the story. Tell us the story of what happened here. Tell us in your own words what happened. Tell us the story.
All right,
That's normal testimony.
What?
It's normal in court for one
Okay,
of
so
the prosecutor or the defense attorney to say, please tell us the story in your own words. That's a standard deposition thing you're prepared by your lawyers to do. So I don't see why we have to break it out.
In a deposition, you're answering questions. You're not telling your story. You're not given freedom to tell
Even
the story.
I've done 100 depositions in the
But in any case, you want to
Stephen, I've done 100 depositions in the prep. The lawyer says you will be asked this question. Please tell the story in your own words. That's a normal question. So I don't know
Okay,
why we have to break.
Okay, I apologize. What do you want to do with this thing? You want to take it out?
Yeah,
Take the whole thing out?
it's redundant.
Okay. How do we feel
You
about
want
that,
to
folks?
hear the guy's story? Just ask the person's story. Just ask them.
Okay, so we're going to remove that. Everybody?
Yes.
The second.
Okay,
Mhm.
Okay.
okay, just a second.
What happens
Just-
if the chairperson is not present? Witness, does that mean the witnesses are not able to be called? Ken?
The chairperson is not present. The rest of the members who are present will appoint somebody to work, to act as the acting chairperson for that meeting.
Maybe we should put that in.
I think so. Witnesses will be called by the chairperson or the acting.
No, witnesses shall be called by the BOE. Again, you only act as a board.
Okay, so the first sentence needs to be revised then.
Okay, it's going to say witnesses will be called by the BOE at the discretion.
Nope,
Well,
that's it. Period.
Okay, all right.
Okay,
Second sentence has been deleted.
so if we're doing that, then two sentences above, the chairperson shall preside over the hearing and shall rule on all objections.
That's fine.
Okay. Because we need a leader. That's, okay.
Oh, wait,
Moving
it's
on.
something here. Yeah, wait a second here. Yeah.
What's next?
Okay. We're on 5, right? Just
Well, we could
under,
also, I'm sorry, Craig, on page 4 at the bottom, just to be consistent, witnesses may be questioned by the BOE and their counsel, right? Which tracks the language in the point above.
Sounds good. Witnesses may be questioned by the BOE and their counsel.
Mm-hmm.
Is that okay?
Yep, I am.
Okay, now we're on
Sounds good.
5.
one other thing on the next bullet point. It says New York Public Officers Law or other federal. Shouldn't federal be capitalized? As
Okay,
Yes.
usually,
okay, very
So
good.
that same provision and also down at the bottom of the page, Stephen, I looked back over a memo that you had written to us where you made the point, you say, who is responsible for researching and determining whether any laws, regulations, so questioning these provisions and the fact that they're in this document. So I thought that was a very good question. Do you have any answer for that?
I'm just basking and being confident on having a good question. I'm sorry. Take me a minute. I don't have, I left it out because I didn't know what to do with it. I didn't know, I certainly didn't want to be responsible for having to do it. I don't know,
Ken, this is a draft. The basis of this draft was something that was provided by Steve Leventhal. And as you can see, it refers to the New York Public Officers Law and then any other law that may come into play. And the question mark here is whether we should be making reference to laws we simply have no knowledge of.
Oh, okay. Was there a question there?
Yes, should
What's
this say, Stephen, questioned whether in an October 12th email to us, Stephen questioned whether these references should be in this document. So we're looking to you for advice.
I think it's appropriate.
Okay. Do we know what, I don't know I don't know what it is.
What, the public officers law?
Article 7 of the public officer or any other federal, state, or local law or regulation. I'm happy to leave it in if everybody else, I'm just reading what Stephen wrote in an October 12th, where he wanted it out. So.
I just wanted to know who's responsible for determining this.
Well, I mean, public officers law, it talks about the open meetings law and the Freedom of Information Act. So what it's referencing is whether or not if the document is foilable, it has to be turned over if it's a foilable document. So if somebody files a FOIL, the FOIL officer is responsible for determining whether or not there's an exception in the Freedom of Information law in which the document should not be disclosed. So that's all that's referencing to.
Thank you.
You're welcome.
So we can refer this to the FOIL officer? Is that what we do?
No, you don't refer it to the FOIL officer. If somebody files a FOIL, it goes to the FOIL officer and they make a determination whether or not it should be disclosed or there's an exception which gives the ability to not disclose the document.
Okay. So that's understood and we don't have to worry about it? Is that what you're saying?
Correct.
Susan, you okay with that?
It was your question. So if you're, I was just reminding. So if you're okay.
Well, thank you for reminding me. I guess, if the FOIL comes out of the blue, we have to let it run its course, Continuing?
Under 5.
Yeah.
You just in terms of the third bullet point, maybe you should make that the second bullet point and say the respondent shall submit all or part of the evidence in written form, right? As opposed to in the discretion of the chairperson.
Okay, so we're taking out the first phrase and bringing this up to be the second point, into the second point.
Well, I'm just saying the respondent shall submit in written form. And then the third point is once they've submitted it, then we can say evidence offered by the respondent will be accepted at the discretion of the board, or should it be reasonable?
You want to
right?
flip it. So the first phrase begins with respondent shall submit all or part of the evidence in written form.
Right. And then the third bullet point should say evidence offered by the respondents will be accepted at the reasonable. So I'm not a lawyer. So what? Do we have an obligation to accept it and then rule on it? I mean, what this is saying is, well, we don't like your evidence, so you can't submit it.
Well, no, well, I mean, just like anything else, if the board determines that, I mean, the respondent might want to come in and say, all right, I want to submit the Encyclopedia Britannica as evidence. And the question is, well, is it relevant? Why does the board have to sit here and review and read the encyclopedia if it's not relevant? They might.
Okay, I was just asking the question. So should we just say at the reasonable discretion of the board, or do we need to put that in, or just say discretion?
I mean, no, discretion.
Fine. Okay, no problem.
But the third bullet, which you've just flipped to the second bullet, I'm not sure I understand if it says the respondent shall submit all or part of the evidence in written form. I don't know what that means. Like, they shall submit it in written or part of the evidence. So who determines? I'm not understanding that.
But how else are you going to submit evidence?
Orally.
Okay.
You can submit an audio tape, a videotape. I mean, there's lots of.
All right. I'm just okay. Yeah. So then you can leave it the way it is. All right.
Okay. So we're not making changes on bullet point 2 and 3.
No, I'd just say in the discretion, you can say the respondent may submit all or part of the evidence in written form.
Yep.
Okay. Okay, we all right with that?
Mhm.
Okay, continuing on.
Mhm.
Anything else?
I just think that, as we discussed before, when you're talking about 5I, those are no longer rules of evidence. So we should have a different heading, a number 6 heading.
Okay, so where does the 6th heading begin then for you, Craig?
Maybe it's after a record of the hearing will be kept.
That makes
Okay,
sense.
That should, right?
Makes sense.
okay, so in the heading of number 6 should be rules of evidence? No,
No,
record of hearing?
why don't you say hearing determination?
Hearing determination? Okay,
You can work with that.
okay.
And I just would like to make clear and point, two eyes. The complaint, if any, shall be disclosed to the respondent. But again, we need to make clear that the name will not be disclosed of the complainant.
Well, in general, it's my understanding that if we don't find a complaint to be a violation, that is public. But if we do find a complaint, just the other way around. If we find a complaint that is a violation, that becomes public. If we don't, that is not public, according to our code. Is that correct? Or am I?
I guess yeah, but I think that isn't the question is, doesn't the respondent have to sort of know the accuser, except if it's done anonymously?
I think your rules provide that you do notify the complainants of the determination. If
Yes.
it's unfounded, you got to let them know.
Yes, but
Right.
as the complaint shall be disclosed to the respondent, that's absolutely fair and just, but I question whether the complaints, the writer of the complaint, that name should be disclosed.
Well, that was my question, Susan. If they make the complaint anonymously, that's one issue, but if they does the respondent have the right to know who's making an accusation?
Can we've had complaints that are not made anonymously, actually.
Well, that's my point. Yeah.
Yeah, so can I look to you for your guidance here?
I'm reviewing the ethics code right now to see what it says on it.
Okay, I think there is something about whistleblower, but I'm
Yeah,
not.
there's a whistleblower passage that protects village employees and officers. And that is trying to find it here. Here it is, whistleblower protections. Article 4, 724, B4 on page 18, if you have numbers, on the ethics code, top of 18.
What was the section of the code? 24?
724 B4 on page 18. It's
Well,
just you have the
the
whole
page-
code.
The page numbers are going to differ depending on what font you used. How big
Okay.
you-
Okay, 724
I got it.
B4.
I got it. Yeah, I don't think that whistleblower protection means that they don't get disclosed. It just means that they don't get retaliated against and stuff like that.
Well, how can we legislate retaliation?
Excuse
Or
me?
non-reta- Well, I think there should be protection from naming if, well, anyway, I read that as a little different, but of course, this refers to other laws of New York State. All right, question mark on this one then? Or are we leaving it the way it is?
No, I think it is worth looking at that.
Okay, so we have other laws to look at here that are named in number 4. We'll have to go back and look at those in the interest of moving on, or what?
Uh,
Are we going to decide this now?
The last sentence before decisions, just to wordsmith, but at the conclusion of the hearing, the Board of Ethics may close the record. Again, record.
I have no idea what that means, really.
Right.
I guess it means we have to set a time when no more written submissions will be received, because it could go on and on, I guess. Is that it? We can say enough is enough type of thing. What's the meaning of this? This is the page 6, the next to last sentence or bit there, after the 6th bullet point or 6th thing.
It's
You want-
just I'm not, what's the question? I mean, it's basically just saying, after everybody's testified and you've gotten all the documents, you may say, okay, we're going to close the record, or give the respondent or the complainant an opportunity to do what we would refer to as closing briefs. You know, where the attorney for the respondent says, well, okay, based upon all this evidence, now I would like to give you my legal argument why you should conclude it's unfounded. It gives the respondent an opportunity to articulate why the entire record fails to establish a violation.
Do we
Makes
want to
sense.
add wording? Do we want to add wording about that here?
Yeah, Ken, it would be great if we're probably all in agreement of what you just articulated. And so this can be tightened up in a way that reflects what you just said.
Okay, but that's how I read it. So I don't know. I mean, you want to change the language, that's fine.
Well, I don't know what close the record means. So, I mean, I do, but I mean, this is in a document that is going to be the basis for the way we move forward.
Well, we can just leave it the way it is and then put an extra sentence about opportunity will be given to the plaintiff to submit a closing statement.
Or we could say for the avoidance of doubt, then comma, what you just said. Which always confuse, but that's what lawyers like to put in there, I think, right?
Yeah, lawyers like to create doubt.
For the avoidance of doubt, opportunity will be given to submit a closing statement. The plaintiff will be given opportunity to submit a closing statement.
Not plaintiff, you mean respondent?
Respondent, rather, sorry.
Defendant, yeah.
Is that okay?
We'll see when, well, we're gonna get this and look at it, and it sounds fine, but when we see it in writing, we'll see.
Okay, anything else going on?
That's good to me.
So on page 7, just curious, where it says a copy of the written decision, was that the determination will be provided to the complainant?
Well, here's a problem I have with this, and that is, I as I said before, to me, the code states that a complaint that is founded, that ethical violation, becomes public, but one that is not, I don't know, should that also be submitted to the respondent, to the complainant, or both?
Well, it should go back to the complainant, just so they note that we investigated their claim and found it to lack merit, right?
Well, that statement is fine, but do we have to give them all the details?
No,
No, I don't think so.
Yeah, well, okay, that's fine. I'm happy with that. I just didn't want to, if something's found to be not founded in a violation, then that should be stated, but not then all the other stuff given, right?
right.
Right.
Okay. Anything else in this document?
No, I think it's okay.
Yeah, I have one question. It says the second bullet point, the respondent shall be afforded due process. I don't think it's appropriate to say that after the decision has been rendered.
It should say that if the respondent has been found to have an ethical violation, because that's the whole due process document that we're going to do, right?
Yeah, but
Well,
we should
receive-
have afforded due process before we made a decision. That's all I'm saying.
Yes.
So do we add a phrase here? If an ethical violation has been determined, the respondent should be afforded due process?
No.
No,
No, I think we
No,
can
it
just
was
delete it
afforded.
and then, yeah, I think if we delete that and then incorporate the due process in, then that we don't need to cover it here, right?
Right.
Okay, so we're deleting this?
Yep.
yeah, I would, thank you. Yes, the whole bullet.
Okay. Okay, anything else? Okay, are we now going to consider the due process by itself or as a addition to the first document?
Why don't we edit it and then figure out how to merge it?
Okay. Shall we then start with this next document?
Mhm.
Okay. Comments? This is a shorter document, at least.
Under 2, where you say with 3 copies, numeral 3, I think we should spell out the word 3, right?
Okay. All
And
right.
And again, the universal comment that the Board of Ethics, BOE, which is defined here, should always mean the majority.
Okay.
quorum.
Okay,
Um,
is there a difference between using quorum and majority? Do we need to think about that, or just either one?
Ken?
Again, I don't know where you're putting that language, but by operation of law, you're a board of 5. You're not allowed to meet without a quorum, meaning 3. And in order to vote on anything, you need at least 3 votes. So that's New York state law. So I don't think you need to be putting that into every document that you have.
Great.
But we'll put it in there at some point, just at least once, just so we're clear, I guess.
Okay.
All right. All right. Anything else?
Um,
You know what? If you want, in the first document that we were talking about, where you have purpose,
Yeah.
you can put in there, the Board of Ethics is made up of 5, a chairperson, made up of 5 members,
Mhm.
and a quorum of a board shall be a minimum of 3 members meeting to conduct business,
Mhm.
and any actions taken by the BOE shall be with a minimum of 3 affirmative votes.
Okay. That sounds good. Everybody okay with that?
Yes.
Yes.
Because it's going to be one document anyway, I guess, if we merge it.
Mhm.
Okay. Continuing on.
um,
So I
Under,
think we just merged the 2 purposes, so we have one
right,
purpose, right?
right.
Okay.
I was fine with the procedures.
Under informal, under the procedures, the last sentence, an opportunity to conference with the members of the BOE. So I think it should be made clear that it needs to be a majority, because members could just be 1 or 2.
Okay. So we change that to be an opportunity to conference with the majority of the members of the BOE.
Mhm.
Okay. Page 2. Or this.
Notice, I mean, this is pretty wordy. Why don't we just say if the BOE determines that a hearing is warranted, it will be scheduled, just say in a timely manner. But no, again, the language that Teresa came up with, but no
within a
later than
month.
4,
Not to
4
exceed.
weeks. Yeah, not to exceed, 4 weeks.
Okay. Okay. Anything else?
Well, then the next sentence, we may not need that. The next 2 sentences, because in the other document, we cover those exact bullet points.
Okay, so we're leaving out the last sentence of the first paragraph and the whole thing of the second
No,
paragraph.
we could say the hearing or conference will be, you can leave that. I'm just saying the second sentence, the respondent will provide 6 copies.
Yeah.
Respondent, may be represented by counsel. Those we covered in the procedures for conducting fact-finding hearings, so we don't need those.
Okay. Okay, anything else?
Under 4, it could say if the respondent refutes the charges against them. Instead of to attack or deny, why don't you just say refutes?
Mhm.
Yeah, better choice. Yep. Good. Anything else?
Could say, all right. So if the original violation is held, the disposition and any recommendation statute shall be published. I guess it's elsewhere, any publication rules are defined.
That was a question mark I had as well. I didn't know what that meant.
Well, if a violation is found to be good or bad or provable, it becomes public record.
Mhm.
That's the kind of what the code says. But you're right, it doesn't give us an idea of how we do this or what we do.
Right.
So
Back- Sorry, go ahead.
no, go ahead.
I was just going to say, instead of refutes, disputes sounds a little better.
Yes. Yeah.
Okay. Okay, how do we make public a violation that is upheld? How do we the disposition or the whatever it's called? How do we? Where does that go? How do we
Let's
do
go
that?
to the village website.
Well, that's one idea.
What about we communicate it to the trustees and they deal with it, how they want to make it public?
I like that idea. Gets off the hook. How about that?
Because I think that's what we do, is refer things to the trustees. And
Yes, we're
Yeah,
working.
we are an advisory board.
right.
So that's good. So we
That's
did.
good,
And that's
Teresa.
okay.
Yeah, that's good.
Okay,
Ken, are you
great.
good with that? Just making sure
What?
Ken was okay with that, letting the Board of Trustees decide how to promulgate the information.
Yeah, you can send it to the Board of Trustees, and if you have a recommendation on what the the penalty, for lack of a better word, you can always make a recommendation as well. So you forward it to the mayor and the Board of Trustees. Please be advised that upon a complaint, we have made the following finding, and therefore we find that there was a violation, and our recommendation is X. You refer it to the district attorney's office, or if it's against an employee, we find a violation and we refer it to you for any for appropriate disciplinary action, if any, something like that.
Very good. Everybody okay with that?
Yes.
Thank you.
Great. Anything else in this document?
Nope.
Anything else? Nope.
Nope.
Okay, well, that concludes what I had considered to be our open meeting. And if we have time to continue, we have 3 more documents that are more specific that pertain to an actual complaint. Is that our understanding?
Yes.
So, Attorney Gray, I guess if it's okay with you, we're going to go into executive session after I call Ms. Styler. And we thank you very much for your help. And I will review this recording and my notes and submit a revised document that combines these 2.
Okay, Kat, are you listening in at this point, Kat?
Yeah,
So that
yes, I can pause it and co-host somebody and then come back when you call me.
Excellent.
All right,
So I
let's
think
do
the
that.
chairman's making a motion to go into executive session to discuss confidential information. Is there a vote on that? All in favor?
Aye.
All right.
Aye.
Can we vote to formally open the meeting? All in favor?
Aye.
Aye.
Aye. Thank you, Kat. We just have a minute or 2 left here.
Okay.
In terms of what I'm being asked to do, I just want to be clear. Are you asking me to ask Attorney Leventhal to draft a final decision on the complaints that we've been talking about? What do you want to do? Hello?
Why Attorney Leventhal? I'm sorry, I have bad internet connection. I keep getting,
I
leaving
don't
the
know.
meeting.
This is Susan's motion.
No, I was informed, as we all were, that the village has hired Stephen Leventhal as a special attorney to advise the ethics board in cases where the village attorney is conflicted. We all
When
received
did-
that,
when
we all received that email from the village administrator about a month ago.
So all I'm asking is to be clear about what you're asking me to do. And my assumption is that, Susan, you're asking me to go to Leventhal, who's
I'm
been.
not asking, I'm sorry, I'm not asking you to do anything without the majority of the Board of Ethics, which we have here that votes on.
Okay, well, then I just want to know what if anything, I'm supposed to do. Tell me, vote, make a motion.
Why don't we draft something and have, I don't know, is Leventhal the right attorney? Is there, what is the conflict with the village attorney? I'm sorry, I lost
Well,
internet.
the
connection.
conflict is that Ken Gray officially, as the village attorney, represents the trustees in any action against them.
I see.
This is public forum.
I know.
Sorry. Before we close, do you want to make a motion to have Attorney Leventhal, who's on retainer for the trustees, for the Board of Ethics, have him draft a decision on the complaint?
My question is, why don't we draft something and run it by him? Because his attorney's bills are very high. And I don't think we need him to start all over again.
I'm going to let you vote and decide. I'll propose adjournment unless you want to continue discussion.
I make a motion to adjourn.
I second.
All in favor?
Agree.
Aye.